Facts. In 2005, Randy Michael Knutson, an American citizen, met Rosalina Sybil Knutson in Singapore. They got married and had a daughter named Ruby Sybil Knutson. In 2011, the family lived in the Philippines. However, Randy and Rosalina became estranged after he discovered her extramarital affairs. Anyhow, Randy supported Rosalina and Ruby. Thereafter, Rosalina got hooked in casinos. Randy learned that Rosalina spent weeks in gambling dens and left Ruby under the care of strangers. Worse, Rosalina incurred large debts from casino financiers, prompting her to sell the house and lot, condominium unit, and vehicles that Randy provided for the family. Rosalina then rented an apartment and got herself a boyfriend. Randy advised Rosalina to be discreet in her illicit affairs because it is not good for Ruby to see her mother with another man. Later, Randy discovered that Rosalina maltreated her own mother in Ruby's presence. Rosalina also hurt Ruby by pulling her hair, slapping her face, and knocking her head. One time, Rosalina pointed a knife at Ruby and threatened to kill her. Rosalina even texted Randy about her plan to kill their daughter and commit suicide. Randy reported the matter to the police station, but the authorities explained that they cannot assist him in domestic issues. Afterwards, Rosalina sent Randy her naked pictures with a message that he would not see that body again. Meantime, the neighbors of Rosalina complained about noisy parties and pot sessions in her apartment. The lessor even terminated the lease after marijuana plants were confiscated in the premises. On December 7, 2017, Randy, on behalf of minor Ruby, filed against Rosalina a petition under RA No. 9262 for the issuance of temporary and permanent protection orders before the Regional Trial Court of Taguig City, Branch 69, docketed as JRC Case No. 313. Randy averred that Rosalina placed Ruby in a harmful environment deleterious to her physical, emotional, moral, and psychological development. In an order dated January 10, 2018, the RTC dismissed the petition explaining that protection and custody orders in RA No. 9262 cannot be issued against a mother who allegedly abused her own child. The RTC ratiocinated that the child's mother cannot be considered as an offender under the law. Moreover, the remedies are not available to the father because he is not a woman victim of violence. The RTC cited the ruling in Ocampo v. Arcaiachua that a protection order cannot be issued in favor of a husband against his wife. Issue: whether or not the father of a child can apply for temporary protection order stated in RA 9262. Issue: whether or not the father of a child can apply for temporary and permanent protection order stated in RA No. 9262. Ruling: the case presents an issue of first impression. Example: whether the father can avail of the remedies under RA No. 9262 on behalf of his minor child against the mother's violent and abusive acts. To be sure, there is no definite ruling yet on this question to serve as a guidepost for future cases. Also, the interests of justice and public welfare demand the resolution of the controversy because it will benefit not only the parties but also children similarly situated. More importantly, the petition raises a pure question of law and does not involve an examination of facts and probative value of evidence. Hence, it is an opportune time for this court to answer the novel query with far-reaching implications on whether the father may apply for protection and custody orders against the mother who is alleged to have committed violence against their child. RA No. 9262 allows the father of the offended party to apply for protection and custody orders. In Garcia v. Dryland, the court pointed out that the Congress excluded men as victims under RA No. 9262. The legislative intent is to limit the protection against violence to women and children only. The classification rests on substantial distinctions because women and children are vulnerable victims of abuse compared to men. The difference in treatment is consistent with the declared policy of the law to value the dignity of women and children and protect them from violence and threats to their personal safety and security. In that case, the court likewise upheld the constitutionality of the remedies of protection and custody orders to prevent further acts of violence committed by the offender against women and their children. Inarguably, The offended parties under the law are only women and children. Nevertheless, it is improper to conclude that the law denies a father of these remedies solely because of his gender, or that he is not a woman victim of violence. Section 9b, 26 of RA number 9262 explicitly allows parents or guardians of the offended party to file a petition for protection orders. The exact provision was incorporated in Section 12b, 27 of the Implementing Rules and Regulations of RA number 9262 and Section 8b, 28 of AM number 04-10-11 SC 29, or the Rule on Violence Against Women and Their Children. The statute categorically used the word parents, which pertains to the father and the mother of the woman or child victim. Absolute sententia expositor non indiget. The law speaks in clear language and no explanation is required. There is no occasion for the court to interpret, but only to apply the law when it is not ambiguous. Similarly, the statute did not qualify on who between the parents of the victim may apply for protection orders. Ubi lex non distinguit, nec nos distinguere debimus. When the law does not distinguish, the courts must not distinguish. In any event, AM number 04-10-11 SC states that the rules of court shall apply in a suppletory manner to petitions for protection orders. Under Section 5, Rule 3 of Rules of Court, a minor or a person alleged to be incompetent may sue or be sued with the assistance of his father, mother, guardian, or if he has none, a guardian ad litem. In this case, the title of the petition for issuance of a protection order is unequivocal, to wit, Randy Michael Knutson acting on behalf of minor Ruby Sybil Knutson, petitioner, versus Rosalina Sybil Knutson, respondent. There is no question that the offended party is Ruby, a minor child, who allegedly experienced violence and abuse. Thus, Randy may assist Ruby in filing the petition as the parent of the offended party. On the other hand, Randy is not asking for a protection order in his favor. As intimated earlier, Randy filed the petition on behalf of their minor daughter Ruby. The petition is principally and directly for the protection of the minor child and not the father. Admittedly, Randy also asked for the temporary custody of their daughter because the mother was allegedly unfit. Section 4 of RA number 9262 mandates that the law shall be liberally construed to promote the protection and safety of victims of violence against women and their children. Obviously, the RDC's restrictive interpretation requiring that the mother and her child to be victims of violence before they may be entitled to the remedies of protection and custody orders will frustrate the policy of the law to afford special attention to women and children as usual victims of violence and abuse. The approach will weaken the law and remove from its coverage instances where the mother herself is the abuser of her child. The cramping stance negates not only the plain letters of the law and the clear legislative intent as to who may be offenders, but also downgrades the country's avowed international commitment to eliminate all forms of violence against children, including those perpetrated by their parents. The RDC's consoling statement that children who suffered abuse from the hands of their own mothers may invoke other laws except RA number 9262 is discriminatory. The supposed reassurance is an outright denial of effective legal measures to address the seriousness and urgency of the situation. Suffice it to say that only RA number 9262 created the innovative remedies of protection and custody orders. Other laws have no mechanisms to prevent further acts of violence against the child. In sum, the court refuses to be an instrument of injustice and public mischief perpetrated against vulnerable sectors of the society, such as children victims of violence. The court will not shirk its bounden duty to interpret the law in keeping with the cardinal principle that in enacting a statute, the legislature intended right and justice to prevail. For these reasons, the petition for certiorari is granted. The orders dated January 10, 2018 and March 14, 2018 of the Regional Trial Court of Taguig City, Branch 69 in JDRC case number 313 are set aside. Let a permanent protection order be issued immediately.